Appeal in the matter of Neurim Pharmaceuticals Ltd and another in Generics UK Ltd and another.
Mr. Appellant. Please, Your Lordships. I appear on behalf of the appellant Mylan, together with Dr. Gamza and Mr. Beebe. Dr. Turner and Miss Moggridge are for the patentee Neurim and the exclusive licensee Flynn. There is only one issue for today, and that is my appeal against the order of Mr. Justice Marcus Smith, dated the 7th of March, upholding the validity of the patent in suit as ground 4 in the amended ground of appeal. Neurim has now agreed to give a cross-undertaking in damages in the event that the patent is upheld by this court but subsequently revoked by the EPO. And that being the case, Mylan will not be seeking a stay of this injunction in the event that the patent is, the appeal is unsuccessful.
Can I be clear as to how far that goes?
Yeah.
Do I understand from what you say that if the appeal is unsuccessful, and obviously it's if, you won't be seeking any stay pending an application to the Supreme Court?
Correct.
That's very clear, thank you.
So that's one issue which has fallen away. Nor is what is referred to as ground 3 in the amended grounds of appeal pursued, and that was a contention that the judge should either have found for Mylan or directed a further hearing allowing the parties to adduce evidence in relation to the lay patient argument. Now, my lords, in terms of timing, I anticipate sitting down with a fair wind within an hour and a half or 2 hours. Just before I start, your lordships will have, I'm sure, noticed that the bundles are marked confidential. The vast bulk of the documentation in both bundles is not confidential, but there are 4 documents which refer to commercial information of my clients, which would otherwise have been relevant for the purposes of the stay. Would you like my lordships to, would you like me to identify those documents?
That sounds prudent.
Yeah, so it's core bundle tab 21.
21.
So this is a skeleton argument on behalf of Mylan. And at page 320 of the skeleton, starting at paragraph 46, you'll see some references, 319 rather, I should say. Paragraph 46, you'll see some references to numbers in red. And there's some further references to red numbers in paragraph 48 and also in paragraph 49.
So it's those numbers that you have to be wary of.
Indeed. Well, I certainly shan't be referring to them. They're in the bundles which your lordships have.
Because I think you're saying it may not matter if stay isn't live.
No, I don't think it will matter. That's in the core bundle. In the supplementary bundle, tab 30, there is a witness statement made by Dr. Britton on behalf of my clients at page 312. At paragraph 3.6, you'll see some more red numbers, again over the page down to paragraph 3.9. And then turning on paragraph 317, paragraph 510, paragraph 514, paragraph 515, 516, 520, and 520 and 521. And the same bundle then behind tab 31 is a witness statement made by Mr. Fates on behalf of Neurim. And page 329, paragraph 21. Sorry? 326. Oh, 326, sorry. Apologies. 326. Yes, I apologise. Paragraph 326, paragraphs 5 and 6. And then page 329, paragraph 21. And then lastly, tab 33 of this bundle, page 339, paragraph 8. The number in the fourth line is not in red, but that is the number that has been referred to in the previous documents that we've been referring to.
Yes.
So, Lords, may I ask for a 3122 order in respect of those? Oh, is there?
In addition, in phase 3 at tab 31, as I understand it, although the number isn't in red, at paragraph 23, on the final page 330, that number there, as I understand it, is also...
Should be in red.
Thank you.
Yes. Yes, so it makes sense that you should have your order.
Now, in terms of the background, as your lordships know, the patent in suit is for the use of melatonin in treating a particular form of what is called primary insomnia. And at the priority date, which is August 2001, melatonin was a known compound, although it was not thought to be useful in treating primary insomnia. And the criteria for diagnosing that condition at that time were contained in two publications, the first of which is set out in what I'm going to call the 2020 judgment. And that is at core tab 6. If I could ask your lordships to turn to page 108, paragraph 34. And the judge here reproduces extracts from the fourth edition of the Diagnostic and Statistical Manual of Mental Disorders, DSM-4. And at the foot of the page, subparagraph 4, he reproduces the diagnostic criteria for primary insomnia. And you can see in A, the predominant complaint is difficulty initiating or maintaining sleep, or non-restorative sleep for at least 1 month. Now, there are various additional diagnostic requirements and exclusions at the top of page 109, but they're not material for current purposes. At the bottom of page 109, subparagraph 6, you'll see there the judge explaining that difficulty in initiating sleep is also referred to as sleep onset, or sleep or onset latency, and that terminology comes back into play at various places in the judgment. Now, the second publication was the 10th edition of the International Classification of Mental and Behavioural Diseases, ICD-10. And if your lordships please turn over to page 111 of the judgment, you'll see in the middle of that page, subparagraph 2, a reference to non-organic insomnia. And that is because ICD-10 referred to primary insomnia in those terms. And at the foot of that page, subparagraph 3, we have the diagnostic guidelines, which you see over the top, over the page at the top. Little a, complaint is either difficulty falling asleep or maintaining sleep, or a poor quality of sleep. Now, although the terminology differed, it was common ground that when used in the context of ICD-10, the reference to poor quality of sleep would be understood in the same sense as non-restorative sleep in DSM-4. If your lordships could turn to page 122 of the judgment, table 1 at the top of the page shows the equivalent diagnostic indicators, DSM-4 on the left, ICD-10 on the right. And immediately under that table, the judge says that he will use the DSM-4 and ICD-10 criteria interchangeably, terminology interchangeably. And he goes on to explain that the term poor quality of sleep contains a critical ambiguity. It can refer to the technical ICD-10 term, but can equally be used in the ordinary sense of I had a bad night's sleep. And if we turn on in the judgment to page 132, subparagraph 5, this is paragraph 64, but subparagraph 5, just next to the first whole bunch, the judge explains or refers there to the layman's understanding of the term quality of sleep. That is to say, it would take into account all factors that make up a good night's sleep: difficulty going to sleep, waking up in the night, waking up early, and not being restored, and so on. Now, the existence of those alternative meanings of quality of sleep is central to this appeal. Specifically, by whom and in what circumstances would that term, quality of sleep, be understood in its technical sense rather than its ordinary or layman's sense? And to be yet more precise, when the skilled person reads the examples in the patent, would they understand that the patients who are the subject of those studies, when they were asked to assess their quality of sleep, they did so with the layman's understanding of that term, that is the lay patient argument, or alternatively, did so having regard only to the restorative nature of their sleep and disregarding how long it took them to get to sleep or any periods of waking in the night. And if I can explain why that distinction matters for the purposes of this appeal, if your lordships turn to page 122 of the judgment, paragraph 54, under the heading the coexistence or otherwise of non-restorative sleep. I may refer to that as just simply NRS for convenience, with other indications of primary insomnia. The judge says it would, of course, be entirely wrong to consider these diagnostic indicators or criteria only present alone and not in conjunction with other indicators or criteria. Whilst it's perfectly possible for an individual to present only with NRS, or poor quality sleep, equally an individual may suffer from two or more such issues. The skilled person would know this. Now, whilst primary insomnia is diagnosed by reference to one or more of those three complaints, the claims of the patent are concerned exclusively with non-restorative sleep. And could I ask your lordships to take the patent, which is at core bundle tab 9, and turn to claim 1, which is on page 207. Now, claim 1 is in Swiss form, and just pausing there, this is the specification as granted. Claim 1 has been amended in the course of these proceedings, and the amendments are shown behind tab 31 of the core bundle, but can I just tell you what they are for convenience? In the first line, the reference to within the range of 25 micrograms to 50 milligrams has been amended to 2 milligrams, so it's now an effective amount of 2 milligrams of melatonin. And then in the second line, the reference to a patient in the granted specification has been amended to a patient aged 55 years or older. Same amendments are then included in claim 3. Claim 3. Now, focusing on claim 1, in the second and third lines, improving the restorative quality of sleep in a patient aged 55 years or older suffering from primary insomnia characterized by non-restorative sleep. There's no dispute as to the construction of that language. As far as the patient suffering from primary insomnia characterized by NRS, if your lordships turn please to the judgment, page 150. Paragraph 72, the judge rejects some evidence that was given by Professor Morgan, and he says both claims 1 and 4 refer to a patient suffering from primary insomnia characterized by non-restorative sleep. A skilled person would understand this to mean an individual suffering from the sort of insomnia that I've described in section 5 above. And then as far as improving the restorative quality of sleep, in the same paragraph, picking it up.
Does it matter, Mr. Acton, you said section 5 and it says section C.
Oh,
it doesn't matter, but I just was possible.
Sorry, section C, and I have absolutely no idea why I said section 5. Section C.
It doesn't matter, that's fine.
As far as the improving the restorative quality of sleep, one can see the judge's finding at the end of that paragraph. On the whole, the patent is clear the phrase improve the restorative quality of sleep is coloured by the nature of the symptoms of this individual, and the skilled person would understand that the invention was claiming to ameliorate or eliminate this particular symptom. The meaning of this phrase is clear from the patent. My lords, that is why, when we come to look at the examples in the patent, the issue is whether the experimental results make it plausible that melatonin improves this particular claimed etiology, NRS. Now, the procedural background to the appeal is a little complex, but is set out in the judgment of this court of the 29th of March of this year at Core Tab 12. I'm going to take it as read, if I may, that procedural background. It's paragraphs 22 and onwards. The issues in this appeal have been considered by the judge in various ways in 3 judgments. First, the 2020 judgment, and the subject matter of that judgment was the parent patent, EP702, claim 1 of which was, at least from a patent perspective, indistinct from claim 1 of the patent in issue today. And the claims of that patent, the parent, are set out in the judgment at page 116. Paragraph 43. And the judge held in the 2020 judgment that the claimed therapeutic effect was made plausible by example 2 alone and by example 3 alone. Shortly after that judgment was handed down, the parent patent was revoked, as set out in the procedural background explained in the previous judgment of this court. And that then takes us, in terms of chronology, to what is referred to as the provisional judgment, which is Core Tab 7. If I could just ask you to turn to page 188 of the bundle. In paragraph 13, the judge expresses his provisional view that the divisional, so that is the case, as say the patented suit in these proceedings, was valid for the reasons given in the main judgment, the 2020 judgment. And in paragraph 14, you can see that the judge decided the matter on the papers, and for your note, that included Mylan's submissions of the 24th of January 2022, which is at Core Tab 18, in which we, by which I mean Mylan, set out the lay patient argument including submissions on the statements made in paragraph 39 of the patent, which I'm going to come to in a moment. Now, in paragraph 14, the judge offered the parties an opportunity to persuade him to take a different course, and indeed Milan took the judge up on that offer, principally because he had not in the provisional judgment engaged with the substance of the lay patient argument and our submissions in relation to paragraph 39. So that then takes us to the March judgment, which is behind tab 8 of the core bundle. And we're going to be looking at this judgment, obviously, in due course. But the judge, in this judgment, rejected the lay patient argument for the reasons that he gives. Now, the lay patient argument is, of course, central to my appeal, and I will be addressing your lordships in due course on the judge's reasons for rejecting it in the March judgment. However, it will also be necessary to look at the 2020 judgment, because in the March judgment, the judge referred to certain findings which he'd made in that judgment and some of the evidence that was before him in the first trial.
So, can I summarise the position in this way and see if you dissent from it? The basic document we have to consider is the 2020 judgment, because that is the judgment in which the judge makes his findings of fact as to the common general knowledge, and in which he construes the claims, and where the bulk of his reasoning in relation to insufficiency and in particular lack of plausibility is to be found. When it comes to the March judgment, there was no new evidence and there are no new findings of fact.
Correct.
All he has done is to supplement his reasoning, specifically with regard to the lay patient argument. Therefore, we need to take into account the supplementation of his reasoning, but that's as far as it goes.
Absolutely right. Absolutely right.
Thank you.
Now, in these proceedings, that there is no respondent's notice, and it follows, therefore, that my appeal stands or falls on the judge's findings and his reasoning in both the 2020 judgment and the March judgment. Now, with that introduction, my lords, can I turn very briefly to the law? In paragraph 33 of our skeleton argument, we've included an extract from paragraph 36 of Lord Sumption's judgment in Warner Lambert. And it may be useful to see the entirety of that paragraph, which we find in the authorities bundle, tab 5, page 116. And I'm sure two of your lordships will be familiar with this, but could I simply ask you to read to yourselves paragraph 36.
I did read it myself yesterday, so on the assumption, which I'm sure is a safe one, that my brethren are already very familiar with it. Probably we don't need to spend more time looking at it.
Okay, fine. Jolly. We'll come back to that paragraph right at the end of my submissions. In particular, the Lord Sumption's reference to good faith. So that's the law. I'd like to introduce the patent. And what I'd like to do right at the outset is to simply go through the two key examples, examples 2 and 3. And I have some particular submissions to make in relation to example 3. But I think it may be useful if we just get the content of both examples clearly established. So I'm now in core tab 9, page 205. And looking at example 2, one can see that the purpose of example 2, at least as set out in the first sentence of the method, was to investigate the effect of prolonged release melatonin on subjectively assessed sleep quality and daytime vigilance in 170 elderly patients, primary insomniac patients, aged 68 and a half with a standard deviation of 8.3. Just pausing there, the judge found rightly in paragraph 111 of the judgment, which we'll see in a moment, that at least some of the patients were primary insomniacs whose sleep was characterized by NRS. Now, in terms of the methodology, this was a randomized, double-blind, parallel study, and there were two groups of patients, those who received melatonin and those who received placebo. The melatonin group received 2 weeks of placebo, the last 3 days of which was used to establish a baseline, followed by 3 weeks of treatment with melatonin, the last 3 days of which to establish whether there had been any effect. And then the placebo group was the same protocol, but placebo throughout. Now we then see two questions that were posed to the patients. The first is referred to as a quality of sleep question. How would you compare the quality of sleep using the medication with non-medicated, your usual sleep? And they were asked to mark their response on a 100mm non-hatched horizontal line with two endpoints, either more restless than usual at one end, more restful than usual at the other. And then there was a second question, which is how do you feel now? Same scoring methodology, but the two ends of the horizontal line were marked tired or alert. And then the distance is measured from the right-hand side of the scale. The smaller the distance, the better the sleep or the less tired. And the mean is taken of 3 nights to establish the baseline and to establish the effect, if any. And then if we look at paragraph 33, the results, patentee says it was found that both the quality of sleep and daytime alertness significantly improved with melatonin. Table 1 showing a link between improved restful sleep and less fatigue in the morning. And we can see the data that is being referred to there in Table 1. And so where Table 1 refers to changes in perceived quality of sleep, so that's the first row under the heading in that table, that is the patient's response to that single question. How did you compare, or how would you compare the quality of sleep using your medication and so on? Now, my lords, we submitted to the judge that the reader would understand that when responding as they did, the patients did so as lay people, and as lay people would understand the term quality of sleep in its broad sense. That is to say, taking into account all factors that make up the night's sleep, including latency and maintenance and so on. Now, we also submit that the skilled reader's understanding of the results in example 2 is informed by the patentee's explanation of the results in example 3. So turning to example 3, paragraph 36, again, the effect of melatonin on sleep quality and daytime vigilance, that was the purpose of the exercise. This time, 131 patients, and they are aged 20 to 80. It's the same methodology and the same questions as in example 2, and you can see that at lines 20 to 23. And if we then look at the results, so I'm looking at paragraph 37, the patentee reports in respect of the older patients, that is to say 55 and above, an improvement in quality of sleep and daytime alertness. And then in the second sentence of that paragraph, as far as younger patients are concerned, those under 55, a surprisingly significant worsening in quality of the sleep and daytime alertness compared to placebo. And we can see those results tabulated in table 2. So just concentrating on the perceived quality of sleep question and the responses given to it. The first row is the patients over 55, or 55 and over. And you can see there's an improvement in sleep quality with melatonin of 13.1 millimetres, whereas with placebo, only 7.4. And then row 3, change in perceived quality of sleep with patients aged less than 55. See a very small improvement in sleep quality with melatonin, 1.6 millimetres, but greater with placebo at 13.7. Now, there's no statistical analysis of these data, but nevertheless, the patentee seeks to explain these divergent results in the conclusion.
When you say no statistical analysis, what do you mean by that? I mean, we see that there's no asterisk.
Yeah.
Therefore, there is no claim of statistical significance. Other than that, as I read it, there is silence so far as statistics is concerned.
Yes, maybe I should have put it in a slightly better way. There is no reference to any statistical analysis having been undertaken on these data.
Exactly. So there may have been statistical analysis, there may not, you just don't know.
You just don't know. Indeed. It is certainly not reported.
Yeah.
Did anyone put the numbers into a calculator and produce evidence of the trial?
No. I'm afraid I can't say any more than that.
No, that's fine. That's the answer.
Now, I was just about to take your lordships to the explanation or the account that the patentee gives in seeking to explain those divergent results. And so in paragraph 39, you look at the first sentence, the patentee states that the elderly are more likely to have maintenance and NRS problems. Second sentence, younger people typically have sleep onset problems. The main problem may be due to sleep deficit, not NRS. And then in the third sentence, these results, table 2, clearly indicate that melatonin was effective in primary insomnia related to NRS, but can be detrimental to insomnia related to other etiologies, e.g. sleep deficit due to inability to initiate sleep. Now, we submit that that statement corroborates the skilled reader's understanding of the responses to example 2. The patentee is reporting a poor result with patients under 55 and suggests that this could be a result of problems with sleep initiation. And that only makes sense if the response is catered for quality of sleep in its ordinary sense, rather than being specific for NRS. Because if the answer's related to NRS alone, the effect of melatonin on sleep initiation could not have been advanced as an explanation for the results with the under 55s. Now, this particular point, the submission that I've just made to your lordships, was not taken by Milan in the first trial. It wasn't made by Professor Morgan, and Professor Roth only commented on this part of paragraph 39, by which I mean the last statement, last sentence, very briefly. Nor was it addressed by the judge in the March judgment, despite Milan having raised the point in its original submissions of the 24th of January, and then requesting an oral hearing for it to be dealt with as part of the lay patient argument. Now, Neurim says that without technical evidence, the submissions I've made to your lordships about the corroborative effect of paragraph 39 should be rejected. Can I deal with that now whilst we have example 3 open?
Just before you do, Mr. Acton, let's make sure I understood para 39. The first two sentences, although it says that, although the heading is conclusions,
Yeah.
is this right, that the first two sentences actually aren't conclusions coming from that example, they're statements of what
Yes.
come from somewhere else, and then what you might call the conclusion is then in the last sentence.
I think it would be probably better to characterise the whole of paragraph 39 as actually an explanation,
Right, okay.
which
The stuff
starts...
about elderly patients having maintenance and problems and the 40%, that's not what you get from the data, that's what...
Exactly right.
Yeah,
Exactly right.
Thank you.
Now, in relation to the absence of technical evidence, my lords, what I would submit is this. Experts could plainly give admissible evidence as to what the skilled person would understand by paragraph 39, and specifically whether it sheds any light on the patient's responses to the questions posed. Now, the judge did make findings in relation to the common general knowledge as to melatonin in its capacity for treating primary insomnia, which we can pick up first of all at paragraph 137 of the judgment at paragraph 67. And could I just pick it up as 67 sub 1? And just to get the context, if you look at the first sentence of paragraph 67, Professor Roth was clear in his evidence that at the priority date there was no treatment for NRS sleep, and relatedly there was no recognition that melatonin might play a role in the successful treatment of complaints of NRS. Little 1, the judge records, as Neurim and Flynn made clear, this case is unusual in that there were a number of papers setting out the general consensus amongst persons skilled in the art on this point just before the priority date. And if you could turn on, please, to page 140. In the middle of page 140, under subsection 2, the judge refers to Professor Roth's view was that the consensus papers, of which there were 2, set out the common general knowledge of the skilled person at the priority date. In particular, he noted, and so this is the quotation from Professor Roth, it was known that melatonin could be useful in the treatment of circadian rhythm disorders, but it was not thought to be useful for the treatment of primary insomnia. And then you'll see, just following that quotation, the judge says, I consider that this is a fair summary of what the skilled person would have known or derived from those papers. So that's the, as it were, the starting point as far as the common general knowledge in relation to melatonin in its potential utility for treating primary insomnia. The skilled person's expectation is that melatonin is not going to have an effect on primary insomnia. So what then would be the nature of the further technical evidence that could be adduced in relation to the skilled person's understanding of paragraph 39 and the extent to which it relates back to the questions asked? Now, the court might have decided or sought to decide how the skilled person would evaluate the patentee's account of the age-related incidence of the different etiologies of primary insomnia in the light of the common general knowledge. That is to say, the first 2 sentences of paragraph 39, preceding the what might be perhaps better called the conclusory sentence. The first two sentences are talking about what I call the age-related incidence of different etiologies of primary insomnia. Now, in relation to that issue, one can imagine two possibilities. The court finds that the patentee's account of the age-related incidence of those etiologies is consistent with the common general knowledge. In which case, the patentee's conclusion in the last sentence of paragraph 39 is technically sound. In this study, the patients assessed their quality of sleep as a layman would, and that explains the apparent detrimental effect of melatonin in younger patients. Now, alternatively, the court might find that the patentee's account of the age-related incidence of the different etiologies is wholly misconceived and bears no relation to the common general knowledge. In which case, the patentee's conclusion in the last sentence of paragraph 39 would make no technical sense. But, my lords, in my submission, so what? Because in that circumstance, on those findings, they don't impugn what the patentee discloses in that last sentence, which is predicated on the patients having assessed their quality of sleep, taking into account sleep initiation when answering the sleep quality question. In other words, regardless of the technical evidence, there is a statement made by the patentee, language of his own choosing, which is entirely consistent with my case as to the understanding of the question, the answers given to the question in example 2. Now, with that, by way of an introduction, could I simply turn to my learned friend's skeleton argument, because what we don't see in my learned friend's skeleton is that although there's a complaint that this point wasn't run before, there's no explanation as to why such further evidence could make any difference to the result. So I'm looking at Core Tab 2, page 41. And at paragraph 46, Neurim quotes the conclusory statement at the end of paragraph 39. Actually, inaccurately, the statement is not the results, table 2, it's these results, table 2. But in paragraph 47, in the second sentence, they say, Mylan appears to be suggesting that the data in table 2 support the proposition that melatonin is detrimental to insomnia related to other etiologies. My lords, my submissions are nothing of the sort. No part of my submissions, in respect of example 3, it involves establishing that melatonin is, as a technical fact, detrimental to other etiologies in younger patients. I simply rely on what the patentee says about the results in table 2, that they clearly indicate that melatonin can be detrimental to other etiologies, e.g. initiation. And that statement conveys unambiguously a representation on the part of the patentee that the questions that were answered took into account additional etiologies. Reading on in paragraph 47, about four lines down, my learned friends say the observation that melatonin could be detrimental to other etiologies most likely comes from responses to other questions that were administered as part of the experiment, which are not detailed or included in the data presented in the patent, in particular questions 1 to 3 of the LSEQ, and that's a reference to the Leeds Sleep Evaluation Questionnaire, which we're going to look at in a moment. Now, that submission is simply inconsistent with the language that the patentee uses, because in that conclusory statement, which they have quoted in paragraph 46, the patentee says these results, clearly indicated. These results being the results that are garnered in table 2.
Mr. Ackland, I understand why I understand the point you're making, that they're inconsistent with the language, but isn't that exactly why one has expert evidence? Because one can say, well, there is, for the sake of argument, an inconsistency in the language, but I can tell you that the way the skilled person would rationalise what they can read is that reason, for example. Isn't that exactly what experts do when they read technical documents for the court in a patent case?
Well, yes, and if the, as I sought to articulate a little earlier, the two ways in which that could play out. The rationalisation could be, well, this makes the explanation of paragraph 39 makes sense in light of the common general knowledge.
No. The rationalisations you were giving don't involve saying that this comes from other questions.
Oh, I see. Sorry. Yes.
But the point I'm putting to you, you're showing us.
Oh, I see. I'm sorry.
Speculation, if I can put it that way, from your opponents, but actually the explanation is because there's other questions that were asked.
I see.
And you were making the point, yes, but the language.
I'm sorry.
And I was putting to you that one would have said exactly what an expert might have said to the court had the point been taken below.
And now I understand the point you're making. I accept that. As far as an expert might have said, although it would have to be justified on some technical basis, that this explanation actually makes no sense for common general knowledge reasons. And in those circumstances, the only way of reconciling it is the way in which your lordship has just articulated.
Well, they might have not put it quite the way you put it, Mr. Ackland, but I understand.
Oh, all right, fine. But this
expert evidence because the point wasn't taken.
The point wasn't taken. But my lord, fundamentally, what we have in my overall submission in relation to, and we'll come on to the judge's reasons and his analysis of this in due course, was just looking at the specification. Mm-hmm. We have questions which are asked. We have a methodology that is set out. We have a layman's understanding of what quality of sleep is concerned with. And that explanation as to how the experiments were conducted is of itself entirely consistent with the responses being quality of sleep in the general sense. And there is a statement which, at least on its face, appears to be one in which the patentee is, what I might say, agreeing with my submission.
Yes, I understand. You say because that last sentence says something about a condition other than NRS. The only way that makes sense, given that the way the patent is drafted, suggests the only question relates to quality of sleep, and you say quality of sleep doesn't mean NRS, it can mean wider things. The only way that makes any sense is because the question must have not been understood to be NRS, but general. That's the point.
That's the submission. Whilst we're on this topic, and it's the last point I'll simply make, in relation to my learned friend's submissions, they go on in this section to refer to the EMA report, which is one particular regulatory document. You'll see that reference in paragraph 49 as containing additional information about how the experiments were conducted. And that was published, that report, in 2007, so 6 years after the priority date. And in my respectful submission, I can't see how that can possibly exist with the skilled degrees of understanding of the examples in the specification. Your lordship is frowning.
I'm frowning, I'm thinking.
Oh, okay.
Causes great trouble for my home life,
I may have some further submissions on the EMA report in due course, but they're probably better left to reply when my learned friend has.
I tell you what the thought was. What I was trying to work out was the point you're making there is, what this isn't about is what really happened. What this is about is how a skilled person would read the patent.
Correct.
So even if, as it were, one could look at a later document and say, well, what really happened is they did ask all these other questions, and probably that conclusion does come from other questions. And I tell you why I'm speculating, because I've not thought about that reference, but just take that. You say that doesn't matter, because what we're concerned with is an objective interpretation of the document at the time it was published.
Correct. It's as simple as that.
It can't be interpreted in the light of a document published 60 years later.
Exactly. And just to complete the thought, the point is,
yes,
because this is about interpretation, because it might not be. I mean, this could have been a point about, as it were, the objective reality, in which case it might matter. You might be able to get evidence of what really happened, because we might actually be looking at this for some scientific purpose, to know what the truth is.
Oh, indeed.
But that's not this exercise.
That's not this exercise. The exercise, as you knows, is looking at the document and what it discloses and what that makes plausible. My lords, I'm going to put the patent away and turn to the 2020 judgment. And I'm going to start with the judge's evaluation and findings in respect of the LSEQ, the Leeds Sleep Quality Evaluation, the Leeds Sleep Evaluation Questionnaire. And the significance of the LSEQ is that the two questions put to patients in examples 2 and 3 of the patent are identical to those which appear in this questionnaire. And the LSEQ is significant for this reason, that the judge's findings in respect of this questionnaire and his consequential reasoning are central to his conclusions in the 2020 judgment, and they also inform his rejection of the lay patient argument in the March judgment. Now, the judge's consideration of the LSEQ comes at the end of a section in which he is considering the common general knowledge. And can I pick it up at page 125? Paragraph 60, under the heading Diagnosing Non-Restorative Sleep. The judge sets out some of Professor Roth's evidence on this topic. And could I ask your lordships to look at paragraph 6.36 of Professor Roth's report, first of all. In particular, the text which the judge has underlined. The diagnosis of primary insomnia is made based on the patient's subjective report of difficulty falling asleep, maintaining sleep, or their subjective feeling that sleep has not been restorative. Then paragraph 6.39, the judge is here explaining the importance of what is called a sleep history and what it involves. And in the third sentence of that paragraph 6.39, in addition to exploring the nature and duration of the patient's dissatisfaction with their sleep, the sleep history could cover other aspects of the diagnostic criteria. And then the last paragraph, just to focus on, is 6.40. And the judge, or rather the witnesses, are explaining that in some cases it may also be helpful to ask the patient to complete a sleep diary in which the patient records matters such as their bedtime, the rising time, medications, alcohol use, estimated time to fall asleep, estimated duration, estimated number of awakenings, and the quality of their sleep / restorative quality of their sleep. Now, the judge goes on in this, actually if we just pick it up at paragraph 62, actually to get the context right. Paragraph 61, the judge is addressing some of Professor Roth's evidence as to how the different diagnostic criteria were actually diagnosed or actually were deployed. And the professor's evidence was that they were all to be assessed subjectively. In paragraph 62, the judge finds whatever the position as regards primary insomnia characterised by difficulty in initiating sleep and difficulty in maintaining sleep, it's clear that primary insomnia characterised by NRS is a purely subjective phenomenon because only the individual in question can say whether his or her sleep has been restorative. On the next page, 127, footnote at subparagraph 3, you'll see the judge referring to Professor Morgan's evidence, in which he appeared to suggest that it was common general knowledge that this essentially subjective phenomenon could be objectively measured. And the judge goes on in the next paragraph up to the end of 62, which is on page 130 of the judgment, to reject, in the most strident terms, that aspect of Professor Morgan's evidence. But what he finds, and this is what I want to focus on for current purposes, is paragraph 63. He says, I find that the skilled person would understand that primary insomnia characterised by NRS would be diagnosed in a manner described by Professor Roth in the passages set out in paragraph 60 above. That is, by ascertaining, typically by taking a history, how subjectively the patient considered his or her quality of sleep, using that term in the ICD-10 sense. I interpolate, my lords, in other words, exploring with the patient the nature and duration of their dissatisfaction with their sleep and making a diagnosis on that basis. He then says in paragraph 64, questionnaires might be used to obtain this data. By this data, my lords, he must mean input from the patient as to their subjective assessment of their sleep. And he identifies one such questionnaire to which there was evidence, quite a lot of evidence given, namely the LSEQ. And you can see at the top of page 131 that that questionnaire was considered in a paper by Parrott and Hindmarsh, published in 1978, which was almost 10 years before the appearance of the term non-restorative sleep in the lexicon of sleep medicine. Now, just to get the structure of the questionnaire, there are 10 questions, and you can see that the way that they are set out, actually there are a number of discrete questions, each one followed by one or more criteria for the patient's response. So the first question, how would you compare getting to sleep using the medication with getting to sleep normally? That's answered by reference to 3 criteria, 1, 2, or 3. Next question, how would you compare the quality of sleep using the medication with non-medicated, your usual sleep? And that's answered by reference to 2 criteria, 4 and 5. And as your lordship knows now, that particular question, how would you compare the quality of sleep, combined with the criteria in 4, is what we saw in examples 2 and 3 of the patent. Now, the remaining questions are concerned with other aspects of the patient's sleep, question 9 being the other question in the examples. Immediately following question 10, your lordships can see the instructions that were given to the patient for providing his or her responses. And the judge's approach to the LSEQ and his findings in respect of it are contained in the next 4 subparagraphs of this judgment. And what we'll see is that the judge makes a specific finding as to what the skilled person would understand by the term quality of sleep as it appears in the questionnaire, independent of any particular study. And he also recognises, in the passage that we have looked at right at the outset, that lay people have a different understanding of the term quality of sleep. So starting with subparagraph 3 at the bottom of page 131, the judge says there was a good deal of debate before me about what these questions, in particular questions 4 and 5, were getting at. He then records a submission made by Mr. Van Heegen on behalf of Neurim, on behalf of Milan, as to what these questions were directed at, which the judge characterises in terms of what the answers to such questions would take into account. On Milan's case, factors like sleep latency, wakefulness in the middle of the night, and so on, none of those being relevant to NRS. And the judge records that Professor Roth did not agree with this characterisation and considered that the questions were in fact directed to NRS. Now, The judge doesn't resolve that issue, that is to say, what factors the answers to question 4 and 5 would take into account, for the reasons that he gives in the next paragraph, 64 sub 4. He says, I don't consider that this debate was particularly helpful in terms of resolving the issues before me. He goes on to explain that the questionnaire is only as good as the use to which it's put by the clinicians. He makes findings as to poorly conducted trials, patients not being appropriately selected, questionnaire may not be fit for purpose or appropriately explained. None of that is contentious. And at the end of 64 sub 4, the judge says, context is everything. I don't consider I'm particularly assisted by consideration of the questionnaire, independent of a particular study or research programme. And then 64.5, nevertheless, in other words, he says, that said, the judge goes on in that paragraph, 64 sub 5, to make findings in precisely those circumstances. That is to say, the skilled person, what his or her understanding of the questionnaire would be when that questionnaire is viewed on its own and independent of any particular study or research programme. And he considers, and indeed he finds, is in no doubt that the skilled person would understand the term quality of sleep in the questionnaire to be a reference to NRS, not as it would be understood by the layman. And he is considering, in my respectful submission, the skilled person's understanding of the term quality of sleep in the LSEQ there in a specific scenario. And one can see that from the judge's reasoning. That scenario is first stated in paragraph 64.6a. The skilled person is themselves, the submission is that the skilled person is themselves using the LSEQ and is seeking answers for a reason. And in the last sentence he says, in short, the skilled person using the questionnaire for the purposes of understanding primary insomnia will consider that the questions are directed to the diagnostic criteria for that condition. In the next subparagraph, sub B, the judge then refers to Parrott and Hindmarsh, and he reproduces an extract from Parrott and Hindmarsh, their introduction, and he emphasises, and I say he, the judge, emphasises, because you can see his underlining of the last line of that page. He emphasises the chronological areas of the LSEQ, which are then set out in the remainder of his quotation of that introductory passage from Parrott and Hindmarsh at the top of page 133.
So just to be clear, the chronological is his underlining, is it?
It is his underlining, yes, that's right. Yes. Yes, he says footnote 75, omitting references and adding
No, I
emphasis.
see, yes.
And the chronological areas of the LSEQ form an important part of his reasoning, as we can see from sub C, subparagraph C, because, again, the judge is looking at the LSEQ through the eyes of the person who is asking the questions and what they intend. You can see that from the third line. When seeking to understand what the person asking these questions would be intending, he says that's one of the things that colours the questionnaire, as does the nature of the investigation itself, a factor unknown in this context. A factor unknown in this context must be a reference to a questionnaire being used independent of any particular study or research programme. But you'll see in subparagraph C that the judge attaches significant weight to the chronological grouping of the questions. The fact that the quality of sleep questions are distinct from the ease of getting to sleep. That's GTS, questions 1, 2, and 3. And ease of awakening, that's AFS, questions 6 and 7. You can see that in the judge's account of subparagraph C. So the key submission so far, my lords, is that the judge is finding what the person would understand the quality of sleep questions to be directed at is predicated on the chronological grouping of those questions in the LSEQ. That forms an important part of his reasoning. And as we shall see in due course, that finding is of limited bearing in determining whether examples 2 and 3 make plausible the claimed therapeutic effect, because the patients in those studies were asked only question 4, so devoid of that chronological grouping. But for present purposes, my lords, don't lose sight, please, of the finding in 64 sub 5 that to a layperson the term quality of sleep takes into account all factors that make up a good night's sleep.
Shockley, I'll just make sure I've understood this. I understand the point, of course, that you emphasise, that the judge said that to a layperson, good night, quality of sleep, good night's sleep, have the same meaning. I get that. It's not clear to me that the judge's findings are doing quite what you're saying they're doing, and that's what I want to put to you.
Mm-hmm.
It doesn't seem to me that it's just about the skilled person's intention, as it were, in what they think the study, what the words mean in the questionnaire. Isn't the judge making findings about what the skilled person would understand the results to mean when they administered a questionnaire? Because that's the chronological point. It's not just about the skilled person looking at the chronology and saying, oh, well, that must mean that quality of sleep means NRS. The point is that when you have this chronology, when you administer it to someone, a person, when you're asked questions about getting to sleep, and then you're asked about the quality of sleep, and then you're asked about waking up, it means that the results you give for quality of sleep are what the experts would call NRS.
Okay, I understand the question you're asking. Now, first of all, if that is what if that is what the judge is actually finding, then that is obviously a finding that is made in the context of the questionnaire as a whole.
Absolutely.
Yeah.
Oh, no, I get that. Absolutely. And your point is, well, one of the points I get, which I do understand completely, is that you say, well, actually, they didn't do that. That's not how it would be understood.
Yeah.
In the patent. I get that.
And but as to the more fundamental point, my lords, if one looks, and I don't think I make the submission that one has to look very carefully, in other words, to parse the language that the judge is using in his reasoning very carefully, because the language that he does use does appear to be unambiguous, in the sense that he is, as we saw in subparagraph A, it is through the eyes of the person who's using the questionnaire. That's what he says in A. And in little c, it's again the same point. It's reinforcing that the judge is undertaking this exercise simply through the eyes of the person who's using it.
Yes. But they're using it because that's, in other words, this is what they understand the answers to the questions to mean when they use it.
Well, my lord,
all this is?
my lord, it's curious if that's what it is, because there is no clear finding to that effect.
Which bit of the language do you say is not what I've just put to you? So at the moment, I'm not seeing that it's as ambiguous as you're saying it is.
Right. The language, but let's look at little c.
Little c, okay. So this is 6.
64,
Yeah.
sub 6, c.
Yeah.
Accepting that the significance of these questions will be covered by the date, he's here reminding himself that it's the priority date, when seeking to understand what the person asking these questions would be intending. So he's looking at this through the eyes of someone who is using the questionnaire. So if your lordship is asking what particular language do I rely upon in particular, it is that.
The person asking, underlined for emphasis, these questions.
Indeed.
Yes.
And
But they're asking it for a purpose, which is to get answers.
Right.
I mean, they're not. There's no point in me intending. I mean, that's the bit I'm not understanding. It isn't. The bit that you refer to about a lay person's understanding doesn't say. At least I don't think it does. Please, if I've misunderstood it, please tell me. But paragraph sub 5 doesn't say that a layman answering the questionnaire would think.
No,
That isn't what it said.
No, and that is, I haven't made that submission,
Right.
and I wouldn't make that submission because the judge is simply finding in 64.5 what the ordinary understanding is of the terminology.
Yes.
Yeah.
Exactly. But here he's saying that the understanding of the person asking the questions is that these questions are an investigation to achieve answers to these issues. That's the. I mean,
Okay.
I don't know what else it could mean.
Okay. Well, that's. I understand the question that your lordship is putting to me, and I'll be absolutely blunt about it. Your lordship says, "Well, I can't understand what else he could be meaning," but it is, in my respectful submission, plain as a pikestaff, not only from little c, but also from little a, that he is, for whatever reason, thinking about this exercise simply through the eyes of someone who is asking the question. And that is what one sees at the end of sub 6. In short, the skilled person using the questionnaire for purposes of understanding primary insomnia will consider that the questions are directed to the diagnostic criteria for that condition.
Exactly. I don't think we disagree, Mr. Ackland. I think we disagree about what that conclusion amounts to.
Yeah.
Okay.
I mean,
that's your submission. I understand.
Presumably the skilled person thinks that the answers to the questions are going to further what he was intending to achieve.
Indeed. That is.
And so he was intending to use these questions to find out about matters including non-restorative sleep. So presumably he thinks that the answers are going to help him with that.
I accept the way your lordship puts it to me. It's surprising language for the judge to be using. Let's assume against myself that actually what he's using that language to mean is it's not just what the questions are directed at, but what information the person who's using the questionnaire is going to need to elucidate. The key point is that this is in the context of the questionnaire as a whole.
So it's the questionnaire as a whole, and in circumstances where the nature of the investigation itself, which is an unknown factor, might affect the position.
Correct. It's an unknown entity. Why don't you do that? My junior has just asked me whether it's conventional to take a shorthand writer's break.
It isn't in this.
No, I don't think so.
Of course, actually, the shorthand writers aren't here. I dare say they're watching on a live stream or whatever, and so they can take their break and come back to it.
Very good. My lords, just moving on, I should just briefly address the judge's footnote 76, because this is a footnote that he comes back to in the March judgment. And the judge, in that footnote, he refers to paragraphs 310 and 311 of Professor Morgan's report. And he quotes a particular extract from paragraph 311. And he says he doesn't accept this evidence for the reasons I have given. For the reasons I have given, I do not accept this evidence. Now, we've just looked at the judge's reasons, fundamental to which is the chronological segmentation of the LSEQ. As the judge says in sub C that we've just been looking at, the questions are targeted at specific and separate chronological aspects of a night's sleep. In my submission, the extent of the rejection of Professor Morgan's evidence there is actually quite circumscribed. What the judge is doing is rejecting what the professor says in that because he, the judge, is considering question 4 as it appears chronologically within the questionnaire as a whole.
Why is it right to read it into as narrowly as that? I mean, the judge has just resoundingly rejected Professor Morgan's evidence at a pretty fundamental level.
I mean, are you talking about overall?
Yeah. So he acknowledges that Professor Morgan gave evidence about the meaning of these questions, or rather, the meaning of questions in the sense of the meaning of the answers to the questions.
Yeah.
And then says, for the reasons I've given, I don't accept this evidence.
Yes. So, what are the reasons? It would appear that
Professor Morgan is a charlatan.
I see. Okay. Right. Okay. Well, if
I know the judge didn't use that word. But
No.
I'm paraphrasing the judgment.
I'll come back at the end of my submissions to make it clear what my position is in respect to Professor Morgan. I have, and I would submit, made the submissions to your lordship that when the judge says for the reasons I have given, he's referring to the reasons that he's setting out here. He's got two reasons that follow his interpretation. And when he says these are the reasons, and those reasons are predicated upon the chronological distinctions that are made in the LSEQ, those are the reasons that he's referring to. And just to be clear, my lord, the judge rejected Professor Morgan's evidence in the most strident terms in respect of two particular issues. He also said that in the light of that evidence, he felt that it was important that he would treat Professor Morgan's written evidence as a whole with a degree of caution. I don't, sorry, in my submission when the judge is referring to 76, he's not referring back to the fact that he has needed to express caution about Professor Morgan's evidence overall. He's simply referring to the reasons that he's giving here. Okay. But my lord, I can make it absolutely clear, my appeal does not turn in any shape or form upon resuscitating Professor Morgan's evidence. The findings that I rely upon for the purpose of my appeal are the findings that the judge has made, and in particular the judge's finding as to the ordinary meaning of the term quality of sleep. I just want to make that absolutely clear. I've made my submission that it actually is a fairly circumscribed rejection, but for the purposes of my appeal, actually it doesn't matter. Lord, can we then turn on to the judge's conclusions in relation to plausibility, which start at 166. Or rather, his consideration of example 2 is 166. Page 166. I do apologise. And I think we can take this reasoning fairly briefly. If your lordships look at paragraph 110, the judge recites the relevant paragraphs from the methodology and results in example 2, and he emboldens certain terms. Paragraph 111, he says the test of plausibility is obviously met, and he identifies a number of reasons. It was a reasonably large study. Patients were primary insomniacs, at least some of whose sleep was characterised by NRS. The study was conducted on established lines and resulted in a statistically significant outcome. And where the judge says that the outcome enabled the conclusion that melatonin enhanced the restorative value of sleep, he is referring there to the patentee's conclusion in paragraph 35. That is the way in which the conclusion in paragraph 35 is stated. Now, those four factors are what they are. None of them is contentious. But it's certainly not clear why the judge considers that individually or collectively they would be understood by the skilled reader to render plausible the claimed effect. It was indeed a relatively large study, so be it. But the results of the study, it is the results of the study that matter, not the size of the study. At least some of the patients were insomniacs whose sleep was characterised by NRS, necessary but not sufficient to make plausible the claimed effect. Study is conducted on established lines with placebos and blind testing. Placebos necessary, but again, not sufficient. And then statistically significant in terms of the outcome, again, necessary, but not sufficient. So in terms of, that is the conclusion that the judge has arrived at 111. He then turns in 112 to consider various topics that were raised by Professor Morgan. We can pass over sub 1, that isn't material to this appeal. We can also pass over sub 2 because the judge has found in paragraph 111 that at least some, that is to say, not all of the patients were complaining of NRS. So, in the light of that finding, the observations he makes at paragraph 2 don't, in my respectful submission, seem to advance matters other than a comment on Professor Morgan in circumstances where Professor Morgan had indeed accepted in cross-examination that a proportion of the patients in the study would have had NRS. Now, paragraph 3 is the more important. The judge, it doesn't matter for current purposes, the questions which are in the patent are in fact identical to those in the questionnaire. But he says, for the reasons I have given, such questions, including the clear as framed in example 2, are directed to quality of sleep in the technical sense. And to the extent that Professor Morgan sought to suggest that they were not, I reject that evidence. We've just been through the judge's findings. He footnotes paragraph 62. In fact, he must mean paragraph 64. And I take on board the points that my Lord Justice Birss has indicated. But one thing is certainly clear, is that the reasons which he has articulated previously are question 4, or the quality of sleep questions, in the light of the questionnaire as a whole. And what the judge is not doing at this stage in his judgment is considering whether patients answering question 4 in isolation would be understood to have done so as lay people. We can skip over paragraph 112.4. It's not a key part of the lay patient argument. And then if I can just briefly comment on what he finds in relation to example 3, paragraph 115 on page 168 of the judgment. In the first sentence, he says, I consider that example 3, as with example 2, of itself enables the patent to demonstrate that the invention is plausible. I assume that the judge means that example 3 itself makes plausible the claimed therapeutic effect. In the second sentence, he says that the language makes clear that the focus of the study was the effect of melatonin on NRS, in primary insomniacs. And what the judge, in my submission, seems to be doing is relying upon the reference to NRS in the conclusions, because that is one of the terms that he highlights in his recitation of paragraph 31, just underneath that table. And he goes on to recognize that the absence of reported statistical significance of those results is a relevant factor. But he says, nevertheless, the study shows that there is something in the invention which goes well beyond mere assertion. My Lord, that finding went well beyond mere assertion. Itself went well beyond the evidence that was before the judge. Professor Roth agreed that the improvement with melatonin in example 3 was, in the light of the absence of any reported statistical significance, just an assertion. And we've given you the reference to that evidence in footnote 50 of our skeleton. So that's core tab 1, page 22. But nevertheless, paragraph 116 provides a further insight into the standard which the judge was applying as to plausibility. He refers to Professor Morgan's evidence that the outcome was not clearly consistent with the invention claimed. And the judge accepts that there is some force in these points. But nevertheless, he says they have nothing like the force needed to render the patent invalid for lack of plausibility and sufficiency. So on the judge's approach, data which is not clearly consistent with the claimed effect can render the claimed therapeutic effect plausible. And my lords, in my submission, the plausibility threshold is low, but it's not that low.
When you say not clearly consistent,
Yes.
do you quite mean that? I mean, it is clearly consistent. You mean something more is needed? Something more than mere consistency is needed?
No, what I'm submitting is something that is not clearly consistent. Cannot, of itself, overcome the plausibility threshold. The moment something is not clearly consistent.
I think what you mean, maybe can I try it in a different way?
Yeah.
I think what I think perhaps my lord thinks you're trying to say is information which isn't really anything can't be consistent because it doesn't mean anything. Because if it's not statistically significant, it doesn't mean anything. Is that what I'm trying to put to you what I think you're saying, but maybe you're not.
Well, let me try and put it this way. Consistency would be the bare minimum what one would require of data if it is to make plausible a claimed therapeutic effect.
I mean, if I said, I haven't done the counting, if I made a statement as to how many people there were in this courtroom, that would be consistent with therapeutic effect, but it wouldn't tell you anything.
Yes. Yes, so something more than mere consistency. Yes, okay. And I think, maybe I can put it this way, I think what the approach the judge appears to be taking, if we can put it at its highest, is that consistency is enough. But for the reasons that we've submitted both in relation to 150
He
and
seems to be accepting that it's not even certain that there's consistency. He says some force in the point that the outcome is not clearly consistent with the invention claim.
Yeah.
So he's doubting even that there is consistency.
But nevertheless, plausibility is made out. I won't say any more about example 3. Can I now move on to the two judgments that, or particularly the March
I'm trying to
judgment?
understand just having another look at this, not clearly consistent.
Yeah.
He says, example 3 similar to what he makes in example 2. Selection criteria are the outcome not clearly consistent with the invention claim. It's sort of one of these things about what does the not qualify.
So I didn't.
What does the not qualify? Is it not clearly or not consistent? Consistent but not clearly consistent, or it's clearly not consistent. It doesn't mean that.
No, I don't think it means. I don't think it means clearly inconsistent.
No,
It simply means.
that's definitely not what it means.
It is. He's saying, is it clearly consistent? No, it's not clearly consistent.
Yes, that's,
Yeah.
thank you.
And you say, quite simply, consistency is not enough.
Indeed. Right. I wasn't going to spend any time on provisional judgments because I've already explained the background to provisional judgment. There's no additional reasoning in it. But I am going to now turn to the March judgment. So this is core tab 8. And the judge starts with, there are two introductory paragraphs, and then under the heading affirming the provisional judgment, at 5, the judge sets out the lay patient argument as summarised by Mr. Justice Mead. Paragraph 6, in the second sentence, he says, this was because, in other words, having said the lay patient argument turned on the contention, he says this was because the questionnaire that may have been used to interrogate the patients as to their sleep referred only to the quality of sleep. I'm not sure why the judge says this was because the questionnaire that may have been used, because the lay patient argument turns on the question, not the questionnaire, that was, not may have been used to interrogate the patients and, of course, their responses to that question.
Might he have had in mind that the questionnaire as a whole could have asked other questions?
Well, in my respectful submission, he's wrong to be thinking about the questionnaire at all for the purposes of the lay patient argument. The lay patient argument focuses on one question, which is the question that is posed in the context of the patents.
But if, going back to the earlier discussion, if we envisage that the skilled person thought that asking all the questions could produce something useful,
yes,
then it may not be appropriate just to think about the one question.
Well, that's absolutely right. It wouldn't be appropriate to think about the one question. But in the context of the patent, we do only have
The one
one question.
Isn't that the point? I don't think this to me, I must say, this doesn't feel, frankly, a problem for you, particularly, Mr. Ackland. What as I understand this seems to be saying is it's characterising the issue as, if you ask the question, quality of sleep on its own, in other words, only quality of sleep, then you open up the problem with the lay patient. Whereas if it's quality of sleep is one of the 10 questions in the questionnaire, as he's explained in his previous judgment, you don't open up the lay interpretation argument because in context it's clear what quality of sleep means. And I appreciate you don't put your case only on that basis, for us at least, but isn't what this sentence is talking about is a way of addressing that, which is the same point I think my lord put, that distinction between asking only a quality of sleep question when it's then potentially ambiguous, or asking 10 questions and where quality of sleep in that chronology of 10 questions isn't ambiguous.
Yes, well, in a sense, I would have it both ways.
Okay.
Because if this is an analysis which the judge is doing on the assumption that it is one question which sits within a group of 10 questions, and that is the judge's approach to the lay patient argument, then, as I've said already, that's not the exercise that is engaged by the questions that are posed in the patent, because the questions posed in the patent, there is only one question. Now, if, in fact, what the judge is gearing up to consider is how should the one question that is posed in the patent be answered, and this is simply by way of preamble to his reasoning in relation to that question, then I'm more than content to deal with his reasoning on that basis. Let's pass over the significance of his reliance upon the questionnaire. It certainly is something that features large in the paragraphs that follow. One can see again in paragraph 7 that he refers to his findings in respect to the skilled person's understanding of the questionnaire. He comes back in again in paragraph 9. And I think probably key to the judge's analysis of the lay patient argument is to be found at the end of paragraph 9 and then reading into paragraph 10. Because at the end of paragraph 9, he says the examples would, for that reason, not be worth the paper they were written on. Now, what does he mean by that? Because that was certainly no submission that was made to him on behalf of Mylan. Over the page, he recites the paragraph of our submissions that he has in mind. And then in paragraph 10, he reformulates, if I can put it that way, the lay patient argument. He says the point is that notwithstanding the skilled person's understanding of the terms of the questionnaire, the skilled person would expect the clinicians in charge of the trials recorded in the examples so to botch the trials that they produce meaningless data. Put this way, so this is the way the judge has put it, and Mr. Van Heegen put it far more elegantly for Mylan, the point is hopeless. Well, actually, Mr. Van Heegen didn't put it that way at all, but that doesn't matter for current purposes. But the core reasoning is contained in the remainder of paragraph 10. And in my submission, to get to grips with that reasoning, it is useful, and indeed the judge's analysis in the following paragraphs informs what the judge has in mind. So can I just do that first, and then we'll come back to the reasoning in paragraph 10. So in paragraph 13, the judge, at the end of paragraph 13, says, I can see nothing that I would have asked Professor Morgan or Professor Roth that does not clearly emerge from the evidence heard at the trial. 14, he poses a question that the experts were not asked. And 15, he speculates as to how that question would have been answered. He says not only if the trial was badly conducted. And then turning over the page, just at the foot of paragraph 15, he says, this is the point I was attempting to articulate in 64 sub 4 of the main judgment, which he then reproduces at the top of page 193. And the judge presumably has in mind the reference to the questionnaire being appropriately explained in that passage that he has recited. Because he goes on to quote a passage from Professor Roth's cross-examination in which it was put to the witness that the patients are not given any education as to how to answer the questions. Now, what the judge doesn't do is to make a finding that when asked to complete the LSEQ, the skilled person would expect patients to be educated or directed as to how to answer the questions. And more to the point, the judge doesn't make a finding that when asked to respond to question 4 alone, the skilled person would expect patients to be educated or directed on how to answer it. So there's no finding, and therefore, when we turn back to paragraph 10 and pick up on the judge's reasoning, we can see in the second half of paragraph 10 that the judge's reasons for rejecting the lay patient argument are not based upon any fresh findings. Instead, the reasoning really forms two strands. First of all, the skilled person would expect the trials to be conducted in line with his understanding of what was under investigation, i.e. quality of sleep in the technical sense. And then a presumption that the clinicians intending to evaluate quality of sleep in this technical sense would do their job competently. Now, your lordships have seen the examples. Their purpose is clearly stated: to assess the effect of melatonin on subjectively assessed sleep quality and daytime vigilance. The examples are not said to be for the purpose of investigating NRS, but merely sleep quality. And indeed, turning to the methodology, there's no reference to patient education or instructions as to what factors to exclude when those patients are assessing their sleep quality. The methodology is therefore entirely consistent with the responses being as to quality of sleep in the ordinary or layman sense. And what the judge has done, and in our respectful submission wrongly done, is to construe the examples as necessarily supportive of the claimed technical effect, and then to interpolate a presumption that additional steps not described by the patentee were undertaken.
In other words, he assumes the very thing that is sought to be proved.
Exactly right. And with respect to the judge, he has confused himself as to the ultimate question. The ultimate question is whether the examples make plausible the claimed technical effect. There's no dispute as to the claimed technical effect, and the examples are what they are. The purpose for which they are carried out, what was under investigation, does not change by virtue of appearing in a document where the patentee introduces a claim that melatonin enhances NRS quality of sleep. Still less does the skilled person supplement the patentee's account of how the study was carried out, with a presumption that additional steps were undertaken as part of that study, unless those steps would have been part or expected in the light of the common general knowledge to have been undertaken.
So, as I understand it, what your point is that when the example says it's to assess sleep quality, that's to be read, or quality of sleep, that's to be read in a lay sense rather than in a technical sense by a person skilled in it.
Sorry, could you ask me that question again?
Yes.
You're looking
really trying not to unfairly characterise your argument. I really am. I'm trying to reflect it back in what I understand it to be. The point I think you were making was that the judge, well, you say that the example, the purpose, as the skilled person would read the patent and read the example and read its purpose, is not, they wouldn't think it was to assess NRS, but it was to assess quality of sleep in the lay sense.
Indeed.
That's the point you're making.
That's absolutely right.
But I thought, I'm very sorry if I missed it. I thought when you introduced the examples to us, you were showing us that it meant NRS, what the example was doing.
No, definitely not.
Okay.
Definitely not. I was
my fault, no doubt.
what I was showing you, the overall purpose was to subjectively assessed sleep quality.
Yes.
That is what.
But understood in a technical, that's a phrase, if you will, that has potential technical meaning, which a skilled person could interpret as being NRS.
Indeed, could.
Yes.
And
exactly.
when one then looks at the methodology, let's just pause for a moment. We have patients who are, I'm going to call them lay people, who are asked questions. Well, no, because they cease to be lay people if they get a lot of education. But there's no finding about that.
I couldn't hear Mr. Turner anyway.
Very good. We have patients who are asked to assess their sleep by reference to that question.
Yes.
Now, the skilled person has a technical understanding of what quality of sleep means.
Yes.
The skilled person also must know, as a matter of their common general knowledge, that there is a layperson's understanding of quality of sleep.
Okay.
Let's
Yes,
assume
I mean,
that.
I suspect there probably isn't a finding to that effect.
Yeah,
I think
but
we'll buy that one.
You'll buy that one. When one looks at example 2, it uses the term sleep quality, and it describes a methodology which is entirely consistent with the questions being posed and the questions being answered in the layman's sense.
Right.
There is no finding that it was common general knowledge that questions of this kind, when they're answered, would be undertaken with the benefit of education or instruction that was given to the patient.
Okay.
That is not part of the common general knowledge. Okay, sorry, this is the
But now
submission.
I'll take that from you, Mr. Acton.
Yeah.
That's not the point of my question. The point of my question was that your submission wasn't only about this question of whether the lay person would understand the question that they were being asked to mean the general thing, or the skilled person interpreting the results would think that the layperson was asking that way or whatever. I wasn't really focusing on that. What I was focusing on was a more fundamental question, which I hadn't picked up until recently, which is why I've suddenly reacted, that your submission is that the skilled person reading the patent would not think that the point of example 2 was to investigate NRS, and I'm deliberately using NRS
Indeed.
to avoid the linguistic complications of the problem. That wouldn't think it was about NRS.
Yes.
They would think it was an attempt to investigate the lay meaning of quality of sleep.
Indeed, there's nothing unreasonable about that submission. This is an experiment which is designed, and the method by which it's conducted is one which probes and obtains answers that are relevant to quality of sleep in the general sense. It doesn't have to be quality of sleep in the NRS sense.
I'll accept that for the purpose of this discussion, but paragraph 1 of the patent says the present invention relates to the use of melatonin in the manufacture of medicament to treat blah-de-blah, characterised by non-restorative sleep. So the patent, the field of the invention, is about non-restorative sleep. So when you come and read example 2, it's thought not exactly a stretch for the skilled person reading example 2, but when example 1's a reference. Example 2 is in a patent concerned with non-restorative sleep. It uses the expression which to a technical person means non-restorative sleep, and so one might have thought the example was directed to non-restorative sleep. Now that's a different point from whether the lay person answers when asked a question about quality of sleep. I get that, and that's not what I'm on, but what I'm troubled about is the submission that you would read this example as if its purpose wasn't directed to non-restorative sleep, when it's in a patent whose very first paragraph says this is all about non-restorative sleep.
Yes, my lord, and that goes back to, in a sense, the submission which I've made a little earlier, which is the examples, the data, the experiment is what it is.
Right.
What it discloses, what it will be understood to disclose, can't change simply because the patentee happens to include it in a specification where he makes a claim to something that is on its face, not the subject matter of what is going on in it.
Well, what the patent discloses is to be understood by reading the patent as a whole.
Yeah.
And if it was, for example, the case that one could take the text of example 2, take it out of its context and present it to someone and ask them what it means, you might say, well, it might mean the lay meaning or it might mean NRS. But that doesn't. But just because that's true, it by no means follows that if you pick up that text and drop it into a document which starts by saying this is all about non-restorative sleep, that when you read example 2 in that context, you wouldn't think, well, this is obviously directed to non-restorative sleep.
Right. Well, let's just explore that a little
And
further.
as I said, that's still got nothing to do with what the lay people might think they meant when they were answering questions, which is a totally different issue.
Which is
But
different.
when you're asking what's the purpose of this example,
Yes.
I just have real difficulty given the context in which the example appears.
Okay. Well, I understand the context, and we've got a claim at the end,
And I claim at the end.
and we've got some introductory discussion about quality of sleep using its technical
Well, the
sense.
field of the invention, that's what it says.
Okay, field of the invention, absolutely fine. If this is to be understood as an example that is directed to ascertaining quality of sleep in the non-restorative sleep sense, just NRS sense, I'm just assuming that for current purposes. The difficulty with that is that the experiment doesn't refer to the kind of instructions that would be necessary in order for it to deliver that particular result.
Okay.
And absent a
Hang on,
finding...
non-written.
Yeah.
I think we might be at cross purposes.
Okay.
You
Shall
said
I
it-
start again?
Go on.
I'm reading this against myself for the moment.
Okay.
That when the patentee says the effect of prolonged release formulation of melatonin on subjectively assessed sleep quality, I'm engaging with the proposition
Right,
the Lordship is putting to me,
right.
which is, well, that would be
Imagine
understood.
imagine
That would be
that-
understood to be NRS.
All right.
Yeah. Now, if that were the case, then the methodology that is described on its face would not be sufficient to deliver data that is specific for NRS.
Okay.
Because the only way in which those data could be rendered NRS data
Yes.
would be if there were instructions.
Right.
Now, the
Well,
judge has.
okay,
Can I just finish the
Yes,
point?
of course, sorry.
And the judge has not made a finding that it was common general knowledge that when patients were asked to undertake and answer these sort of questions, that they would be appropriately instructed. Now, if there was a finding, let's put it the other way. Let's
Isn't that exactly
assume.
what he does do?
I'm sorry.
Isn't that exactly what the passage you were just referring to as does say? If your thought was that this is an example directed to non-restorative sleep, then your submission would be understood to mean that they didn't do the study properly.
Now, there are two ways of looking at this study. It's either a study which is done. It's either a study which is done for the purposes which are stated in the example. In other words, it's sleep quality in the general sense. It's agnostic as to whether it's NRS or it's sleep maintenance or it's sleep onset. If the example is understood in that sense, then the methodology that is used is entirely appropriate. Yeah.
But would you accept that, supposing, which is not in fact the case, that at the beginning of example 2, as you were imagining a moment ago, it said specifically that it was about NRS,
Mm-hmm.
a skilled person might then infer, reading on, that a method had been adopted which would produce results which told you about NRS, either by asking the full questionnaire with all the other questions, which we've seen the judge thought the skilled person, I've got muddled in my grammar, which you know what I mean. He thought that asking the whole thing might be productive of answers, or alternatively, even if that weren't the case, the lay patients would have been educated.
In either of those two circumstances, then the data could be probative. Of course, in the present case, there's no indication in the specification that anything more than the single quality of sleep question was asked. And as far as instructions are concerned, there is no finding that it was common general knowledge that patients would be appropriately instructed.
And I follow that. But if it had said at the beginning of example 2, this was all done to test NRS, might it be possible that the skilled person would have inferred that either by asking the full questionnaire or by further education, informative answers would have been produced?
Well, the answer to that question is this. You are the Court of Appeal, and there is no respondent to notice, and there is no finding by the judge that such instructions were undertaken. Therefore, with my respectful submission, is all you can go on is the judgment, the findings, and the reasoning.
But if you're just looking at paragraph 10 of the judgment, which I think is what we were the sentence that it's not the second, the sentence in the middle that starts, the skilled person would expect the trial. Yeah. Judges, I agree with you that the judge's conclusion or the judge's finding is premised on the conception that the reader of the patent would understand example 2 to be directed to non-restorative sleep. That's a point that you've explained and you've submitted that they wouldn't, and I get that. But if the skilled person would think example 2 is directed to non-restorative sleep, then from that premise, isn't it open to the judge to say the skilled person would expect the trials to be conducted in line with their understanding of what was under investigation, i.e. non-restorative sleep, and more to the point, presumption has to be the clinicians conducting trials would do their job competently. That all seems like a perfectly legitimate conclusion for the judge to reach. On the premise.
On the premise. And what does the judge mean when he says would do their job competently?
Right. Well, he obviously means
to
make sure that they get answers which give them answers to the questions they're interested in, which is non-restorative sleep.
And where? I'm sorry to put the question back to your
all right.
Where is the judge's finding that the instructions of that kind were known to be undertaken for the purposes of this kind of investigation. And that's
Well,
why I say
he's
the
he's finding it there. What's wrong with that? I don't understand what the problem is.
Right.
You may disagree, but
Well, my submission, there's no finding. My submission is that the approach that the judge has taken is to elevate these experiments in such a way that they will be read even in circumstances where there is no such finding.
I mean, in a situation, as I understand, there wasn't evidence to the contrary. It wasn't. You weren't coming along saying there was evidence to the contrary on this point. I mean, this is why this is also slightly unusual, because there was a trial where this wasn't really the big point.
Indeed.
And then a judgment comes later.
Indeed.
So you take the point, and the judge reaches a conclusion there. And I take the point, as I keep repeating, it's on a premise about the interpretation of the example.
Mm-hmm.
But on that premise, you say there's no finding. He's reached a conclusion there. Surely, if you were coming to this appellate court and saying, well, we produced evidence to the contrary, which the judge hasn't taken into account, then I can understand the point. But you didn't.
No, absolutely right.
So how was he? What's wrong with what the judge has done in para 10 on the premise of the interpretation?
Well, I'll say it again, my Lord, because he hasn't made a finding.
Right.
And my Lord, what he has done in paragraph 10, in the second half of the two strands of that reasoning, more to the point, the presumption has to be that clinicians conducting the trials intended to evaluate the quality would do their job competently. Now, that's a presumption that the judge is writing into his analysis. A presumption, but in circumstances where he hasn't made any findings as to what that actually means in terms of doing their job competently.
To make findings of the kind you're talking
Sorry?
about. You didn't give him an evidence base on which to make findings of the kind you're talking about. Did you?
The Professor Roth was cross-examined on the instructions, and he's quoted the relevant passage.
Yes.
I'm not going to refer to...
You're not saying that this conclusion is contrary to the evidence of Professor Roth?
My Lord, what I do say is that the evidence that is relied upon, or that the judge refers to in paragraph 16, so this is of the March judgment.
Yeah.
If we just take it in stages, the question, the patient who's being asked these questions is not given any education. Answer, they're given directions, as I understand it, to judge the quality of the nature of the sleep. Question, they're simply asked the questions which you see in the appendix. They're asked to mark on that scale. Is that correct? Answer, on the previous night. Question, so what I'm putting to you, Professor, as a matter of common sense, is that any patient answering question 4 will take into account all the aspects of their sleep, their previous night's sleep, when deciding whether the patient has a restful or less restful night's sleep. Answer, no, I don't agree with that. Answer, question again, what I suggest to you is that, as Professor Moore will understand, that's exactly what the skilled person will understand. If you, no, I don't, there's then a series of exchanges. But fundamentally, the professor disagrees. But what the professor hasn't done in any part of that cross-examination is to say, no, look, it's not just the instructions that are given at the end of the questionnaire where you have to mark out on the analogue scale what your score is. These people are actually educated, and they would have to be educated that when they do, when they answer this question, they exclude from their consideration how long it took them to get to sleep, whether they work.
You haven't produced this evidence. All you have is Mr. Van Heegen asking some questions.
I do.
And getting a no, essentially, from the witness.
Absolutely right. But fundamental, my lord, what I do have in the judge's analysis is the findings as to what the layperson understands by the term quality of sleep. That is the starting point for the analysis. The layperson understands quality of sleep in its general sense, and it is lay people who are being asked these questions. And how can their answers be elevated so that their responses are specific for NRS? That can only happen if they are instructed that when answering that question, they are to exclude from their consideration matters such as the time it took to get to sleep and so on and so forth.
And if you produced an expert who said that and could be cross-examined on it, then I can understand the submission, but you didn't.
Well,
whose evidence was accepted.
well, what I don't want to get drawn into, because as I said, it's no part of my appeal, is to seek to resuscitate Professor Morgan. In fact, Professor Morgan, when he was cross-examined, made it clear that if one simply asked the question alone, then that question wouldn't elicit a response that was specific to NRS. So show that transcript.
No, it's all right.
But
You
it's,
made it clear you're not relying on Professor Morgan.
Yeah.
Okay.
But just to circle back to the fundamental submission, is when I showed you Lord Sumption's statement in paragraph 36 of Warner Lambert, where the Lord Justice Lord Sumption is careful to explain that the test of plausibility can't be relegated to essentially an article of good faith. In my respectful submission, that is what's going on in paragraph 10 of the judge's analysis. My Lord, I've got two final points, if I may make, as far as the lay patient argument. One is what I would call the final point in the jigsaw in respect to the lay patient argument. You have my submissions that responses to quality of sleep in examples 2 and 3 would be understood by the skilled reader to take into account all the factors that make up a good night's sleep. That's the core of the lay patient argument. Now, as a matter of fact, of course, if all of the patients, the subject of the examples, had been diagnosed as primary insomniacs suffering only from NRS, that is to say, NRS was their only complaint, and they were not complaining as to sleep onset or maintenance. If that were the case, then the answers to the quality of sleep question would necessarily have been specific to NRS. But that is not the case. It was common ground between the experts, and the judge found, and I showed you this in the judgment, at paragraph 111, that at least some, but not all of the patients would be understood to have to be primary insomniacs whose sleep was characterised by NRS. And then lastly, I can't resist but respond to what my learned friend says is a lacuna in my case, and it's in paragraph 39 of his skeleton argument. Which is page 40 rather. And at the end of paragraph 39, he says that leaves a lacuna in their case. If it's not common general knowledge that the exacting instructions are required, why does the skilled person consider the results implausible when those instructions are not referred to in the example? We wait to see how Milan developed this point. Because there's nothing implausible about the results per se in the example. As I've said many times now, it was a methodology that was set out to investigate on its face quality of sleep in the broad sense. And the methodology is consistent with that. And without the common general knowledge that the patients would have been instructed to answer that question in a specific way, to exclude from that consideration difficulty of getting to sleep or periods of wakefulness, they would be understood to have adopted, as the judge said, or rather, the judge's characterisation of the layperson's understanding of quality of sleep. As I've run over slightly, if I can be any further assistance on my submission.
Thank you very much. Dr. Turner.
My lords, sort of three headline points which I think we'll need to get to in due course. First of all, we say the references to the layperson, which is really the foundation on which my learned friend built his case, is not to be a reference to patients or participants in the clinical trials with which they're concerned with. The judge made that clear in the March hearing. He hasn't put it in the judgment, but
how can you rely upon something the judge said in the course of argument, which isn't in any of his three judgments?
Well, my lord, we say the starting point is there's no reason to equate the layperson with the subject in one of these clinical studies. And the other thing on that to bear in mind is that they're not, the subjects in the studies are not in a loose sense being asked, how was the quality of your sleep last night? And they're actually engaged in a process of scoring how restful or restless their sleep was.
How do you know that? That doesn't come out of the questions that are quoted in example 2.
Well, have a look at it, my lord. I think it does. Perhaps it'd be convenient actually to turn it up at this stage. So if my lord goes to example 2, and this is there's quite a bit of science behind all this, which my learned friend has not referred to, but which we'll need to look at. If you look at example 2, my lord, paragraph 32, if we take it from line 50, quality of sleep question was, how would you compare the quality of sleep using the medication with non-medicated, your usual sleep? The patients marked the level of perceived quality of sleep on a 100mm non-hatched horizontal line with 2 endpoints. The left endpoint was labelled more restless than usual, and the right endpoint was labelled more restful than usual. So, my lord, that's the task they're engaged with. And as we shall see, this was the standard way of assessing NRS at the priority dates, and that was part of the common general knowledge. Also, why we've got example 2 open. It's quite useful just to look at the conclusions. My learned friend was saying that this example is being put forward as a sort of, sorry, I don't want to unfairly paraphrase him, but as a general exploration of quality of sleep. But that's certainly not how the patentee is addressing it. If you look at 35, patentee is saying these results show that melatonin enhanced the restorative value of sleep in these primary insomnia patients. Obviously, we're going to come back to these issues. My lord, we say that this patent, for the first time, discloses evidence that shows melatonin improves the quality of restorative sleep. And it discloses a phase 3 clinical trial with 170 patients, which it summarises. But that is example 2, and it also discloses another trial with 130 patients, which is example 3.
Sorry, you say it discloses a phase 3 trial. Does it anywhere say it is a phase 3 trial? I mean, one always gets into debate as to where the dividing line between phase 2 and phase 3 is. It describes a trial which is undoubtedly randomised, double-blind, 2 parallel groups, and with a reasonable number of patients, 170. But whether it's in fact truly a phase 3 or phase 2B, one doesn't know. It's probably not stated.
My lord, that makes a fair point. It probably doesn't matter for my submission.
I don't think it matters at all.
And having reviewed the data, and having heard the expert evidence, and having preferred the evidence of Professor Roth over Professor Morgan, the learned judge made a finding that these experiments rendered the patented use plausible. And what my learned friend does, my learned friend, as I understand it, is not challenging the judge's analysis of the law, the legal principles, or even the application of those legal principles. My learned friend is submitting that the judge reached a conclusion that no reasonable judge could have reached on the materials before him. And my lord, that is a significant hill, my lords. That's a significant hill to climb in our submission. One has to be very cautious when my learned friend is sort of island hopping from different parts of the documents and indeed the judgments and tying up ends which have not been tied up by the learned judge. One needs to be extremely cautious. And in our submission, there's no proper basis on which to challenge these findings of fact. And when one examines the facts in more detail, which I'm going to, we say the judge was plainly right. Before turning to the issues on the appeal, we invite the court to keep in mind what's not in issue in this hearing. There's no dispute in these proceedings at all that the use of melatonin to treat non-restorative sleep was inventive at the priority date. Second, there is no dispute that the therapy works, that it improves the quality of restorative sleep, and there's no dispute that the invention could be put into practice, that the skilled person, skilled addressee would not know how to perform experiments equivalent to examples 2 and example 3. Indeed, the clinical trials which are reported in the patent, and I accept my Lord Justice Arnold's caution about this, but those clinical trials did form part of the submissions to the regulatory authority.
But the skilled reader of the patent doesn't know that. I mean, the evidence establishes that, and I'm not questioning it in any way, but the skilled reader of this patent doesn't know what was subsequently put into the regulatory authority.
But it allows my Lord to test what my learned friend is saying. My learned friend is saying that if you apply a sleep questionnaire, your subjects may be confused as to how to answer those questions. That's certainly not the view taken by the regulatory authority. So that's why
you say this is a real-world test of plausibility.
This is a real-world test of my learned friend's submissions.
But the regulators may have been given a lot more information about how it was done, presumably.
Of course. But we can see what they say about it. And,
yeah, but was there? I can't detect from the judgment there was any full investigation before the judge as to precisely what was in the dossier and precisely what the regulators made of it.
No, I mean we have the EMA report. I mean, slightly different. I've got my learned friend running points which he readily acknowledges there's no evidence to support, and obviously, my lord, there's an extent to which we can look at materials that are in the case to rebut those submissions. Yeah. Before turning to the experiments of the patent, one needs to just keep in mind aspects of the common general knowledge. I can take this very quickly because my learned friend has introduced you to a number of these passages. My learned friend showed you, I'm using, the internal numbers of the judgment, I hope that's not too inconvenient.
We're in the main judgment.
It's 108, I think it will be the... well, we only have one criticism of the judgment, my lord, and that's the learned judge's use of paragraph numbers, which is somewhat difficult to follow, so it's sometimes easier for page numbers. But the findings, my learned friend showed you these passages, so that's on page 24, paragraph 34. He went down to primary insomnia at the bottom, and my lord saw that was how it was defined in the DSM-4. That was one of the standards at the time. But my lords, if you could also keep in mind the diagnostic features, that's paragraph 5 on the next page, and there's a citation, the first paragraph, and if you go to the second paragraph, it says, individuals with primary insomnia often report a combination of difficulty falling asleep and intermittent wakefulness during sleep. Less commonly, these individuals may complain only of non-restorative sleep. That is a feeling that the sleep was restless, light, or of poor quality. So, my lord, one can see there the connection of restlessness, which was being investigated with non-restorative sleep, and that forms part of the DSM-4. My lord, I then was going to just pick up 36. I think my learned friend showed you that. That's the ICD-10, And just only, I think he might have shown you paragraph 2, so that's, yes, 36.2 on page 27.111. And again, just at the end of that first paragraph, it's talking about insomnia as a condition unsatisfactory quantity quality. And then at the end it says, conversely, there are people, that's the end of the paragraph, who suffer immensely from poor quality of their sleep, whilst quantitatively judged subjectively and or objectively as within normal limits. And then I think we can probably then move on to page 37. And my learned friend showed you the equivalence of the criteria. And then he showed you the paragraph under the table on page 38, where the judge makes reference to the critical ambiguity and the layman's use as opposed to the technical use. And of course, poor quality of sleep can, as we all know from our personal experience, be more used loosely. If you're woken up with a phone call in the small hours of the morning with a request to go and carve a cow on a hail-swept hillside in the North York Moors and have the pleasure of watching the dawn rise as you return home, you may well comment when asked that your quality of sleep was poor. And one can envisage other situations, parent of a young baby, somebody who's spent all night binge watching Netflix, etc., saying the same thing. My lord, that is not what this patent is about. That is not the experience that the skilled person, skilled addressee understands the patent is about, and it's not what the person, the patient in a clinical study understands what it is about. And that's why we say there's no reason as a starting point to equate the lay person who might have been up all night doing an interesting task or dealing with a crying baby, no reason to equate that person with the patient in a clinical study.
And sorry, you say the patient wouldn't have understood that this is what it was about.
Well, the patient would, in my submission, there's no reason to assume that a patient in a clinical study is the same as a layperson. So I've given my lord the example of...
But that's what I don't understand. I mean, I'm not sure this point is in any way necessary to your argument, but insofar as you're making it, I just don't understand it. Patients, by definition, are lay people. They are not medically educated. They don't know what DSM-4 is or ICD-10 is. They don't know the diagnostic criteria. So how can you say that patients are not lay people?
They're not. They're people in a particular situation. And what the learned judge didn't do...
ordinary people in off the street being asked questions as part of an exercise. And I understand your emphasis and reliance upon the fact that it's as part of the exercise. But as those human beings are concerned, they're lay people. They're not medically educated.
Yeah, but my lord, they've gone through all sorts of... There have been all sorts of discussions, of course, with the lay people.
How does one know that? There's no findings of fact about that, and there's nothing in the patent about that. Of course, you can rely upon the context, and that's a separate issue.
Yes.
But you can't say that these people are not lay people, can you?
Well, in terms of qualification, I of course agree with my lord. In terms of their qualifications, one assumes they're not sleep experts. One accepts that. But what we don't accept is that that there is a reason for equating the reference to layperson in the judgment with the way that people would behave if they were patients in a study. And that is a jump my learned friend makes. And I just wanted to remind my lord, I understand my lord's point that it's not in the judgment, but I do still want to point to paragraph 44 of our skeleton, if I may, and just remind my lord of what the judge said in argument. And I can't rely on this as a finding. I appreciate that.
Well, particularly since it comes after the main judgment.
Yeah, my lord. But I mean, what's wrong? We ask rhetorically and use it as a rhetorical tool to say what's wrong with what the judge is saying here. I'm emphatically not using the word layman as the patient. That's what he said. And
looking at the judgment, this all gets off the ground at that subparagraph 5 of a paragraph that I don't know the number of.
yes.
But it's on page 132 of the bundle. That's the one that refers to the quality of sleep in the questionnaire. And it says rather than using it as a layman would, the point you're making is that the judge there doesn't actually, as it were, complete Mr. Ackham's thought for him, that is referring to patient in a study. And you might say, well, of course, patients in studies are laymen. I understand that's the point you're putting.
Yes.
But your point is, that may be right, but you've got to be careful what the judge actually found. And he wasn't there answering that. He doesn't, on the face of it, answer the question about a layman in a study.
No.
But is there any reason to suppose that, absent some larger group of questions or some particular education, these patients in this study wouldn't have understood quality of sleep in the way that lay people
They have no knowledge, my lord, of concepts of restorative sleep or why they're answering questions in the technical sense, of course. But one needs to be realistic. A patient in a clinical study will, of course, have received instructions. Of course they would. First of all, they've got to be told where to go. They've got to be told, it's got to be determined whether they are suitable. It's got to be determined, are they allowed to stay up all night and go to a nightclub? Are they expected to sleep in bed in a sleep centre? Are they expected to sleep in a bed at home? Are they meant to carry out their normal activities? Is that the instruction? Of course there's going to be and those instructions may be maybe nothing more than please behave as you normally do, don't do anything unusual. Can they take drugs? Can they take other drugs? Can they take alcohol? There's obviously going to be, and the skilled person will appreciate this is not a completely random, uncontrolled, in that sense, small c event.
And then it becomes key, does it, to know whether the skilled person reckons that this study was done specifically for this purpose.
Yes.
Because if it had been done in relation to quality of sleep generally, one couldn't infer that the patients answering the questions would have answered the question in any way other than the normal lay way.
Well, the normal layperson isn't asked, doesn't have a piece of graph paper put in front of them and asked, was your sleep more restful or more restless? Please do it on a score of 0 to 100. And what happens, the patentee didn't just come up with this system on a wet Wednesday afternoon. There's a scientific study behind this as to why this is a relevant question and why this question is indicative of non-restorative sleep. And that's the Parrott and Hindmarsh paper. We'll be going to that in a moment.
It's focusing on the judgment, the layman bit of the judgment. The judgment doesn't say that the question, the worst quality of sleep coupled with the bar running between restless, more restful, and more restless would be understood that way. That's not the finding.
No.
The finding is only about the term quality of sleep.
Yeah. My lord, exactly. That's exactly the point. My lord, how is NRS diagnosed? My lord, I've shown you the bit on page 25. There's no, by the way, my lord, just jumping ahead, there's no way of diagnosing it other than asking questions 4/5 in the sleep evaluation questionnaire. That is how you do it. And that is what the patentee did in a large-scale clinical trial. My learned friend showed you the case being run by Professor Morgan, that you had to use actigraphy. I don't know if I got that word right, but a movement sensor on your wrist. That was the case that was being made. This isn't the way to do it. You have to use a movement sensor on your wrist. And this drew the severe criticisms from the learned judge. My lord, I don't think we need to go through those at the moment. And then the judge at paragraph 64, which is on page 46, I think. So paragraph 63, we have the finding, you've been shown this. Skilled person would understand that primary insomnia characterised by non-restorative sleep would be diagnosed in the manner described by Professor Roth in the passages set out above. That is by ascertaining how subjectively the patient considered his or her quality of sleep. Questionnaires.
I've lost the reference.
Sorry, my lord, it's 130 the bundle, I think, 46 internal.
Thank you.
And there was a finding at 63. This is after the judge had dismissed Professor Morgan's evidence. And then he says questionnaires might be used to obtain this data. And then my learned friend has taken you through the questionnaire. And we see at 3 a good deal of debate before me about what these questions, in particular questions 4 and 5, were getting at. Mr. Van Hagen contended that questions 4 and 5 were directed at quality sleep in the non-technical sense. So this is was a submission being made that, look, this LSEQ, questions 4 and 5 are not suitable. In other words, the answer to this question would take account of factors like slow sleep latency, wakefulness in the middle of the night, which are obviously relevant to insomnia in general sense, are not relevant to insomnia characterised by NRS. Professor Roth did not accept this characterisation of the questions and considered they were in fact directed to quality of sleep in the ICD-10 sense. So you have a finding there, that's what these questions are directed to.
What does directed to mean?
That they are, well, directed to means that's what they adduce evidence of. And then we have the finding, I think my learned friend's shown you at paragraph 5, no doubt that the skilled person would attach a technical meaning to the term quality of sleep, would understand it to be a reference to NRS, rather than as a layman, taking into account all the factors to make up a good night's sleep. Then he says he reached this conclusion for the following reasons, that's at 6. Just at the end of that, in short, the skilled person using the questionnaire for the purpose of understanding primary insomnia will consider that the questions are directed to the diagnostic criteria for that condition.
And is that going to be a convenient moment?
Yes, my lord, that is a convenient.
In which case we'll resume at 2 o'clock.
What was?
No.